In the previous segment, I mentioned that on November 17th of 2015, the University of Michigan belatedly released additional records in response to my subpoena. One of those records was an email from Al Pacha, my former employer, who on July 21st approached the university to make the false accusation that I sent direct threats to him. In the same email, he also requested to meet with the university as soon as possible, and that meeting happened in the next morning on July 22nd. Although the release on November 17th did not include any information as to what Al Pacha told the university employees, I knew for sure that I never threatened this intermediary. For that reason, in the night of November 17th, that is few hours after I learned about Al Pacha's false accusation, I sent an email to Al Pacha with copy to several managers of the university, and I demanded Al Pacha to retract his defamatory statements. Few days later, Al Pacha responded through an attorney, refusing to retract his defamatory statements with the excuse that he interpreted as a direct threat the proverb "what goes around comes around," which I wrote in my emails on June 20th and July 1st. Few days later, I filed my lawsuit against Al Pacha for defamation and other counts. In the next segment, I will address the nonsense and fallacy of Al Pacha's pretext. For now, I will focus on what Al Pacha told the university employees during that meeting on July 22nd. Al Pacha directed his email on July 21st to 3 employees of the university, my 2 managers or supervisors, and someone who Al Pacha calls Anne. He actually meant Amy Ranno, the human resources administrator of the university. Al Pacha didn't even know the name of the person he wanted to meet with. He just knew that he wanted to sabotage my prospective employment with the university, and that is why Al Pacha took the unprecedented step of involving the human resources administrator of the university. As of that point, all the interactions between Al Pacha and the university regarding my employment were with the other 2 supervisors, Ed Triska and Ronald Lovelace. These 3 employees attended the meeting with Al Pacha on July 22nd. 2 of them testified in either one of my 2 lawsuits, and additionally, the Associate Director Lukeland Gentles testified in my lawsuit against Maria Viggers. According to the deposition of these 3 witnesses, Al Pacha told the university employees that I threatened him, that once I became employee of the university, I was going to use my position to influence the university so as to negatively impact Al Pacha's business with the university. Of course, this coward intermediary didn't show and didn't even offer to show these employees the emails of which he was complaining. Al Pacha obviously knew that if he showed those emails, his fraudulent narrative would be immediately disproved. Al Pacha testified that he didn't show those emails because that's none of their business. So according to Al Pacha's business ethics, it is totally fine to disparage the reputation of somebody and to present to the client a fraudulent narrative, but when it comes to proving those statements, that is not the client's business. Anybody who reads the emails I sent to Al Pacha can attest that I never made any such threat. My only references to my prospective employment at the university are in the sense of why it was not reasonable for me to rely on Al Pacha's promises given his erratic behavior. This is what I explained in the first segment. However, one or more witnesses who testified in my lawsuits mentioned under oath that Al Pacha attributed to me that statement of threat. In fact, Al Pacha fabricated his story to make it sound like a violation of one of the university's guidelines in the topic of contracts and vendors. So Al Pacha falsely portrayed me as someone who is looking forward to violating the guidelines of the prospective employer. Whereas the three witnesses gave a pretty consistent testimony as to what Al-Pacha told the university on July 22nd, those same witnesses incurred various inconsistencies and even contradictions on other matters, especially those related to Maria Vigors. That reinforces my suspicion that Maria Vigors may have been the real cause as to why the university severed its relations with me. Let's not forget that Al-Pacha's defamatory email was sent within 6 hours from the time the police served upon Maria Vigors the personal protection order against her. The University of Michigan and Al-Pacha may have reached an agreement to make it look like a conflict or a dispute between Al-Pacha and me, because that would look better than admitting the fact that the University of Michigan severed its relations with a victim of harassment. In the meeting on July 22nd, Al-Pacha offered the university to provide it with a replacement, somebody who will perform my functions. That should have prompted suspicion among the university employees, in the sense that maybe Al-Pacha had a conflict of interest that motivated him to make his accusations. After all, Al-Pacha was calumniating the person whom the university selected for a position that the university created precisely to stop paying the hefty commissions it had been paying to Al-Pacha since 2007. But instead of exercising a minimum of scrutiny or responsibility or even of morals, the university blindly welcomed Al-Pacha's offer of replacement. When I asked Mr. Gentles during his deposition as to whether he ever suspected that Al-Pacha may have had a conflict of interest, Mr. Gentles' answer was that they saw Al-Pacha's information as credible. Mr. Gentles is in charge of allocating the financial resources of the university, and this response during his deposition portrays him as somebody who makes financial or contract decisions simply based on whatever an intermediary comes up with. Forget about making any investigation or inquiring any further. Whatever Al-Pacha says is law for the contract decision. Then Ms. Amy Ranno testified that she didn't request proof of Al-Pacha's accusations because she thought that somebody else, in this case my immediate supervisor, was going to request that proof. But then Ms. Ranno testified that she was one of those who recommended that the university severed its relations with me. So there is a contradiction. If she was still expecting that proof, why did she make the recommendation? Or vice versa. If she made the recommendation, why would she expect that somebody else will collect the proof of Al-Pacha's statements? And I don't know what to say about Mr. Lovely's response that he doesn't know why I was never inquired or asked about the fraudulent statements spread by Al-Pacha. It looks like Ron Lovelace was simply working or living in a hypnotic state. One inconsistency in the deposition testimony of Mr. Gentles is that he portrayed himself as the final and sole decision maker regarding my prospective employment with the university or at the university, as well as my contract with the university through Al-Pacha. But then Mr. Gentles proved to be clueless, totally clueless about the fact that the university had suspended much earlier my work visa process and my hire process as a result of the criminal actions that Maria Vigors was incurring at the university. Instead of shutting up because he was under oath, Mr. Gentles improvised his theories as to why my work visa process may have been halted, and Mr. Gentles reiterated his doubt that my work visa process was suspended at all. So it is quite interesting that Mr. Gentles, the final and sole decision maker, was kept out of the loop when Amy Ranno and other directors of the university decided to suspend my work visa process in April of 2015. I should mention that Mr. Gentles hardly ever appears and is hardly ever mentioned in the several documents that the University of Michigan produced in response to my subpoena. That weakens the notion that Mr. Gentles was the final and sole decision maker. One despicable detail about this person of name Lukeland Gentles is that he testified that Al-Pacha's accusations were one of the reasons, in plural, for the university's decision to withdraw the offer of employment. Because Mr. Gentles only testified about Al-Pacha's accusations of threat, and Mr. Gentles was totally clueless about Maria Vigor's criminal actions, which she began in March of 2015, I was very interested to know what other reasons Mr. Gentles had in mind when he gave that answer. That is why I made further questions so as to gather detail about those purported reasons. And after his evasive answers, Mr. Gentles eventually conceded that Al-Pacha's statements were the only reason, not one of the reasons, for the university's decision to sever its relations with me. Of course, then Mr. Gentles tried again to inflate the matter by making references to Al-Pacha's decision to terminate my employment. Obviously, Mr. Gentles has never been the victim of defamation, and he has never been the victim of a conspiracy that results in the loss of his source of income. But Mr. Gentles is an adult, and he was under oath. He should have been more responsible in the answers he gave under oath, instead of inflating and exaggerating matters to prejudice a plaintiff who was trying to ascertain the truth so that he could get justice served. I don't care if Mr. Gentles was unraveling his perversity or whether he was following instructions by the university's attorneys, but a deposition is not the right occasion to behave like a pig. Unlike the practical inexistence of this final and sole decision maker named Lukeland Gentles in the university's documents, one of the employees appearing most often in the university's records is Amy Ranno. However, she decided to play the role of amnesic witness during her deposition by resorting several times to the answers "I don't know" and "I don't recall" and on matters related to Maria Vigors, despite the fact that Amy Ranno was centrally involved in the communications regarding the unlawful actions that Maria Vigors was committing in 2015. It is as if the university's attorney instructed Amy Ranno before the deposition that she pretend to be demential, because it would be catastrophic if Amy Ranno disclosed the information that the university had been trying to conceal from me since the beginning. Additionally, I should point out that the deposition of Amy Ranno happened on December 17th of 2015, and only a day later, the university released additional records in response to my subpoena from August. That prevented me from asking Amy Ranno for further detail on the content of those documents and the circumstances of the events. Like I said previously, the university only complies with its legal obligations only when it is convenient to the university itself. Amy Ranno testified that she was unable to recall whether the university made any attempt to contact Maria Vigors, but one of those belated documents shows that Amy Ranno herself informed her co-workers that Amy Ranno called Maria Vigors on April 29th. Additionally, Amy Ranno requested that one of her co-workers be present as a witness during that phone call, which is very unusual for an office setting of a university or an institution such as the University of Michigan. That makes it very hard to believe that Amy Ranno was unable to recall whether the university attempted to contact Maria Vigors when Amy Ranno herself actually spoke with Maria Vigors. Amy Ranno was also unduly apologetic by minimizing or outright denying the detrimental effect that Maria Vigors had on my prospective employment and my employment situation at that time. For example, Amy Ranno testified that at some point the university regarded the Maria Vigors situation as a family issue, despite the fact that the university never actually resumed my work visa process, which it had suspended as a result of Maria Vigor's actions. Amy Ranno testified that the university eventually resumed my work visa process, but that it could not be completed because Amy Ranno had a lot of work to do and she could not access the proper forms. That excuse makes no sense whatsoever, because we are talking about a time span of 3 months during which the University of Michigan made absolutely no progress regarding my work visa process. Moreover, the university's international department or international center is in charge of the major portion of the work visa processing, and Amy Ranno's role in the process is limited to filling a questionnaire. But instead of filling that questionnaire, Amy Ranno ended up spending much more time dealing with the unlawful actions by Maria Vigors and participating in the deliberations with the other directors of the university. Thus, it is unreasonable for Amy Ranno to deny the negative impact that Maria Vigors had on my prospective employment with the university. In my brief to the Michigan Supreme Court, I developed an analogy to illustrate how disingenuous and nonsensical Amy Ranno's apologetic testimony is. The analogy consists of a criminal who shoots her victim multiple times. The paramedics don't arrive, and after a long period of agony, an opportunistic individual kicks the victim and the victim dies. During the subsequent court proceedings, the paramedic testifies that she was going to save the victim, but she couldn't because on her way to the scene of the crime, there was a lot of traffic and the paramedic couldn't access the proper roads, but that the victim's death was not the result of the criminal's actions. That is exactly what Amy Ranno is doing for the sake of favoring Maria Vigors, despite the clear evidence that Maria Vigors prompted the university to suspend my work visa process and my hire process. Here, the long time during which the paramedics didn't arrive represents the 3 months during which the University of Michigan simply made no progress regarding my work visa process. The evidence in which Amy Ranno is involved clearly shows that Maria Vigors certainly had the negative impact. On the email on April 22nd, Amy Ranno was announcing the interruption of my work visa process as the result of what Maria Vigors was doing back then by even involving the FBI. Then the subsequent email shows that my process has been paused, and even on July 21st, that is 3 months after my work visa had been suspended, Amy Ranno made the comment that new issues keep cropping up around me. The wording of that sentence reflects that I was still prejudiced as a result of Maria Vigors' unlawful actions, because other than that, there were no actions or incidents involving me that would deserve the expression of new issues cropping around me. Given Amy Ranno's absurd shielding of criminal Maria Vigors or Amy Ranno's fake dementia during her deposition, maybe the truthful answers to this matter can only be found in the redacted lines from the email that Amy Ranno wrote on April 29th, or maybe in this paragraph that the university entirely redacted. It is odd that the university has to conceal so much information from an email of which the subject matter are the facts leading to the lawsuit against Maria Vigors. It is outrageous that the University of Michigan entirely redacted 3 pages from the email that Lady Rastige or Rastig wrote about me 3 days before I was terminated. Imagine how much information those 3 pages contain about me and which is relevant to my case against Maria Vigors and possibly also to my case against Al-Azhar. But when the university employees simply do not cooperate in their depositions, and when the University of Michigan keeps playing games with the subpoenas, it is impossible to gather details about the circumstances of the events and about the information of essential documents. This only shows that the University of Michigan has so much to conceal in this matter, And of course, that is a bad sign as to the University of Michigan's lack of transparency and lack of integrity. The depositions of the university employees show how suddenly the University of Michigan changed from the extreme of pointing to Maria Viggers as the only person liable for the defamation against me and for the interference with my prospective employment, to the opposite extreme of denying during the depositions that Maria Viggers had anything to do with the university's decision to sever its relations with me. The university incurred that inconsistent change of opinions despite the demonstrated fact that the University of Michigan suspended indefinitely my work visa process 3 months before Al-Pacha came up with his false accusations, and as a result of the unlawful conduct by Maria Viggers in 2015. To do that drastic and inconsistent change of representation, the university produced a witness who was severely misinformed and who was very prone to speculation, and the other witness who, although she was centrally involved in the issues with Maria Viggers, behaved as a totally or highly demential witness during her deposition. In these circumstances, I filed a motion to compel the university to produce the entirety of the documents that it heavily redacted, as well as any other records that the University of Michigan has not yet produced. After all, the documents that ensued while the events were developing are much more reliable than after the fact testimonies from employees of the university who, for the sake of keeping their jobs, are willing to comply with any unlawful direction that the university attorneys give to them. As is the case here, because Carter-Ranno incurred perjury, and possibly the same could be, maybe the same can be said about Lukeland Gentles. The hearing for my motion happened on January 6th of 2016, and the University of Michigan litigated that those documents were protected by the attorney-client privilege. Now, let me say as a side comment that the attorney-client privilege is a very vicious and outdated evil that should no longer exist in the judicial system. It is outdated because nowadays the vast majority of people know how to read and write, and thanks to the internet, we have free access to thousands, maybe millions of court opinions that explain how the law is applied in situations or how the law is implemented in controversies. It is also a vicious recourse because the attorney-client privilege impairs the ascertainment of the truth, and as a consequence of that, many criminals are able to get away with their unlawful conduct. During the hearing, Judge Carol Kuhnke reviewed the email, and only the email that Lady Rastig wrote about me 3 days before my termination. Judge Kuhnke admitted that the email contained information which is directly relevant to my case. Then Judge Kuhnke took a break and went to the headquarters of hell, which is also known as Judge's office. She stayed there for a few minutes. I have no idea what happened during those minutes. Maybe Judge Kuhnke was negotiating some favor with the university. But the fact is that Judge Kuhnke came back with a ruling favoring the university precisely on grounds of the attorney-client privilege. Judge Kuhnke also made the pointless comment that the email that she reviewed contained firing and hiring decisions. But that is irrelevant or pointless because part of my lawsuit deals with the damages, the economic damages and the injuries to my career as a result of Maria Viggers' interference with the university. So it is obvious that if I am filing a lawsuit because of my loss of employment, The evidence is expected to contain discussions about firing and hiring decisions. At that hearing and on multiple occasions, I reminded this judge how central the university is in the lawsuit. Maria Viggers knew that I was working at the university's facilities, which is the reason why, in her efforts to sabotage my employment, Maria Viggers was harassing and threatening the employees of the University of Michigan at the same time that she was calumniating me. Given that the university is the main source of information needed to adjudge this lawsuit, the university should not be allowed to continue concealing that much information through the heavily redacted records and the witnesses who simply do not cooperate. To that, Judge Kuhnke simply gave the blatant answer that many injustices are unremedied because a person is unable to gather the evidence needed to make the proofs. As far as my extensive litigation experience with this judge is concerned, that is the deplorable way how Judge Carol Kuhnke makes a living. First, by issuing rulings that prevent a party from ascertaining the truth, and then few seconds later explaining to that party, although in a very mediocre way, why so many injustices are unremedied. At that point, Judge Carol Kuhnke willfully became the main obstacle to the ascertainment of the truth, insofar as she as judge has the authority as well as the obligation to ensure that the truth is disclosed in some way or other. And by then I had already proved to this judge that the University of Michigan was not forthcoming, and that for months the university was making false and misleading statements in response to my inquiries about my subpoena. In the previous segment, I mentioned some examples of records that the university willfully concealed from me and how I discovered them through separate venues by investigating other entities. That's what I proved to this judge. Additionally, I pointed to this judge the inconsistencies in the deposition testimony of Lukeland Gentles, and I denounced the fake dementia that Amy Ranno exercised during her deposition. I want to direct your attention to Judge Kuhnke's subtle attempt at the end of the hearing to discourage me from further pursuing the full disclosure of the document which she just read a few minutes earlier. Judge Kuhnke referred to the email by Lady Rasteig as the information I think I need. Now, it's not just information that I think I need. It is information that Judge Kuhnke herself recognized as directly relevant to my case before she got in her office and came back with her obstructionist ruling. The fact that I didn't fall for Judge Kuhnke's misleading expression is attested by my subsequent filing of a motion for reconsideration and one or two supplements to that motion, because I was really interested in persuading this judge to reverse her ruling so that I could access such important documents. Judge Kuhnke thinks that fooling a pro se litigant is as easy as misleading a puppy at home. Also, at the end of the hearing, Judge Kuhnke stated that she was not willing to violate the attorney-client privilege. But in this matter, there was no need for violation of that privilege. The attorney-client privilege has some limitations. One of them is the crime-fraud exception. The Michigan Supreme Court stated in one of its recent opinions the concept of silent fraud, which it defined as the fraud that is committed by suppressing facts where circumstances establish a legal duty to make full disclosure. Such a duty of full disclosure may arise when a party has expressed to another some particularized concern or made a direct inquiry. Here, in my controversy with the University of Michigan regarding the attorney-client privilege, the circumstances that established a legal duty on the university are the subpoena which I served upon the university in August of 2015, then the direct inquiry that I submitted to Amy Ranno by email and which Amy Ranno never responded, and then the direct inquiry I submitted to John Lund, who in October of that year made the false and fraudulent statement that the university had fully complied with my subpoena and that there were no more records. And then it turned out that the university's HR department was aware of the phone calls that Maria Vigers had made and that the university concealed from me. We also saw how the university also had information regarding Al-Pacha's accusations, and the university only released that information when it was convenient to the university, but otherwise it would not have disclosed them. The Supreme Court of Appeals of West Virginia gives further clarification by stating that in the context of crime-fraud exception to the lawyer-client privilege, fraud will include the commission or attempted commission of fraud on the court or on a third person. That will be me. For the exception to be operable, the fraud contemplated need not have been actually committed. The mere intent to perpetrate the wrongdoing will suffice. But hey, Judge Carol Kuhnke doesn't care all that much about the legal precedent that the Michigan Supreme Court and the Supreme Court from other jurisdictions carefully formulate in their analysis of controversies. Judge Kuhnke is in the judicial office to perpetrate others' crimes and to violate the rights of the law-abiding civilians. In general, the purpose of a court hearing is for the parties to emphasize the key points of their positions and to clarify whatever issues remain confusing to the judge, who is supposed to have read the motion briefs in preparation for that hearing. That is reflected in the court's motion policy. If the judge makes a question, the litigant has to answer that specific question. At the hearing on January 20th of 2016, Judge Kuhnke had a colloquium with Finley the Idiot as to what she guessed were my concerns, and of course Finley the Idiot was brainwashing this judge on the basis of the perjured or inconsistent testimonies by Lukeland Gentles and Carter-Ranno. After several minutes of spinning her wheels on a relatively minor issue, Judge Kuhnke stated that she was unable to understand how is it that Maria Vigers affected me on that issue. I answered her question as I was supposed to do, but I remember thinking, seriously, what is wrong with this judge? I have been explaining the whole issue in previous motions and I have attached supporting evidence. This is not rocket science. Judge should understand that by now. At the hearing on February 24th, that is a month earlier, I figured out what was going on. Judge Kuhnke stated that her understanding was that all the evidence pointed to phone calls that Maria Vigers made around July 21st. That is what happened. Judge Carol Kuhnke had been issuing her sloppy rulings throughout the entire complaint, thereby blocking pretty much all of my discovery venues, even though Judge Carol Kuhnke had no bare clue about any of the evidence that I had been filing in court since the entry of my complaint. Had Judge Carol Kuhnke been a little bit diligent about her job, she would have been aware by February 24th of 2016 that Maria Vigers began harassing the university in March of 2015, not around July 21st. Had Judge Carol Kuhnke been a little bit diligent about her job, she will also know that it was not only through phone calls but also by emails how Maria Vigers was conducting her illegal activity. I attached that evidence as exhibits in my complaint. They were in redacted form, but then I resubmitted them in a subsequent motion in unredacted form, and that motion was for the hearing which happened on October 21st. But if Judge Kuhnke doesn't even open a complaint, which is the initial document of any lawsuit, she's not expected to read any of the subsequent motions, let alone the exhibits or the evidence attached to them. Also, Judge Kuhnke could have learned by doing her job, which she obviously didn't, that the university stopped my work visa process in April of 2015. Not around July 21st, and that was the result of the unlawful conduct by Maria Vigers. That is what happens when your case in court is presided by a charlatan and extremely incompetent judge as Carol Kuhnke. That your case is decided based on obscure and corrupt interests of a judge instead of being decided based on your merit in the case. Judge Carol Kuhnke's inadvertent showing of her exorbitant negligence is also revealing from the standpoint that phone calls made by Maria Viggers around July 21st are what Judge Kuhnke understands to be all the evidence. But as of that point, all the evidence that Judge Kuhnke had seen was the email which Lady Rastaik wrote about me 3 days before I was terminated. Those 3 entirely redacted pages that the University of Michigan doesn't want me to see. The comment that Judge Kuhnke made on February 24th at hearing permits several conclusions. First, that Maria Viggers called the University of Michigan around July 21st, which is a violation of the personal protection order against her. Second, that the University of Michigan violated its duty to notify me if Maria Viggers approached the university again, which I requested to the university's managers in my email on May 5th of 2015. Third, that the university's allegation that it severed its relations with me because of Al-Pacha's accusations is only a pretext and a cover-up of the continued illegal activity by Maria Viggers. And fourth, that Judge Carol Kuhnke colludes with criminals and endorses the unlawful conduct by institutions such as the University of Michigan. Of course, if we ask Judge Kuhnke directly about this matter, she will deny and she will disavow her comment. But what can you expect from such a judge who first tells me that she will not stop me from my discovery on Down Foods, and just 2 weeks later she prohibits me from doing that, claiming that this is a different matter. Given the university's reluctance to disclose the contents of the redacted documents and given the obstructionist rulings by Judge Kuhnke, I decided to take the deposition testimony of the university's executive director, Richard Robin. Initially, I didn't like the idea of taking another deposition because each one usually costs hundreds of dollars, and that is quite expensive, especially when the witness fakes dementia, as Amy Ranno did, or when the witness is severely misinformed and engages in malicious comments and speculation, as Lukeland Gentles. But it still made sense to take the deposition of Director Robin because he was the most frequent recipient of the defamatory and harassing emails that Maria Viggers sent, and also because when Amy Ranno notified me in April of 2015 that the university stopped my work visa process, she told me that it was Director Robin who gave the university's international department the instruction to stop my work visa process. When I notified the university my intention to take the deposition of Director Robin, an interesting development ensued, which shows the hypocritical politeness of these people. Because the attorney for the university, Dave Mason, initially answered that he appreciated that I wanted to take the deposition of Director Robin, although the university was going to oppose my initiative in court. Seriously, it is shocking how much the university is afraid that I gather information which it has been trying to conceal from me, to the extent that the university is willing to spend resources on its expensive attorney to oppose my deposition or my initiative to take the deposition of Director Robin. The court hearing happened on February 2nd of 2016. The university's attorney argued that he was in charge of over 1,000 employees and that the subpoena deposition was oppressive. In response, I argued that Director Robin is not involved in, or he does not get involved in the termination procedures of each one of its 1,000 employees, and therefore the fact that he was involved in the deliberations regarding me is pretty indicative of the high caliber of the case, also indicative of that he might have information which neither of the two previous witnesses wanted to disclose. Surprisingly, Judge Kuhnke ruled in my favor, and that is pretty much the only time when this judge made any ruling that favors me. Although, because the university stated that Director Robin was sick, and he was on sick leave, and he had not yet returned to work, Judge Kuhnke made the comment at the end of the hearing in the sense that I should wait for more days instead of taking the deposition of Director Robin right after he came back to work. Remember what I said in the second segment. One of the tactics that Judge Kuhnke has for obstructing justice consists of kicking the can down the road. Thus, during the hearing on February 24th, Judge Carol Kuhnke stated that she already authorized me to take the deposition of Director Robin. Then at the next court hearing, which happened on March 16th of 2016, at a point at which I was still unable to take the deposition of Director Robin because the university was ignoring my emails, Judge Carol Kuhnke dismissed my lawsuit, thereby preventing me from taking the deposition of Mr. Robin. That is how dirty this judge of name Carol Kuhnke is about justice. By the way, the University of Michigan terminated Mr. Robin a few months later in July of 2016. The reasons that the corrupt judge gave for dismissing my lawsuit, or in other words, for favoring criminal Maria Viggers, are that Maria Viggers' act didn't cause me any harm and that I was unable to prove that Maria Viggers made her defamatory statements with malice or actual malice, which is the short form of saying that Maria Viggers knew that her defamatory statements were false. Of course, both excuses given by Judge Corrupt Kuhnke are false and fraudulent. To prevail in a defamation lawsuit, the plaintiff has to prove that a false and defamatory statement was made about him or her, and that that statement was made to a third party such that the communication is unprivileged. That means that the party made his or her defamatory communication to people other than a police or to her attorney, or that it was not made during a judicial proceeding, and so forth. The plaintiff also has to demonstrate that the communication was made with a mental state of at least negligence, or even worse, such as actual malice. And the plaintiff also has to demonstrate that the communication was either nefarious, such as when somebody is falsely accused of a serious crime, or that the false communication caused harm or economic losses to that party, such as the loss of business or loss of employment. These four conditions constitute what is known as the prima facie elements of a defamation lawsuit. The legislature or the Supreme Court of each jurisdiction is in charge of formulating the prima facie elements of an offense. Examples of offenses are fraud, defamation, promissory estoppel, and tortious interference. Although each jurisdiction is free to define or formulate its prima facie elements as however it pleases, every judge in that jurisdiction has the obligation to strictly adhere to that formulation. This means that the judge is not allowed to alter the prima facie, and the judge is not allowed to come up with some fabricated variation of that prima facie. But that is exactly what Judge Carol Kuhnke did in this lawsuit. By lending credibility to the University of Michigan's employees who testified that they didn't credit the defamatory statements made by Maria Viggers, Judge Kuhnke impermissibly altered the prima facie elements of the defamation lawsuit. As we just saw in the formulation of the defamation prima facie, there is absolutely no requirement that the third party admit or testify in a judicial proceeding that he or she credited or believed or was influenced by the defamatory statements. There is simply no such requirement, and that makes sense because, as we see with Carter-Ranno and Lukeland Gentles, witnesses are likely to depart from the truth, especially when they have malicious intentions or when they are trying to keep their job, and they don't want to risk their source of income by contravening the directions of the employer's attorney. Moreover, in this case, in this lawsuit, there was evidence, documents from when the events developed, and therefore after the fact testimonies of demential or misinformed witnesses was not even necessary. For the sake of denying that Maria Vigors made her defamatory statements with actual malice, Judge Kuhnke essentially advocated for this criminal by stating that the complexity that Maria Vigors devoted to her unlawful acts is not at all inconsistent with her mental illness. It was entirely inappropriate for this judge to play the role of defense counsel. A judge is not supposed to do that. In any case, Judge Kuhnke should have filed an appearance for Maria Vigors and team up with Finley the Idiot, but not preside a lawsuit where Maria Vigors is the defendant. Additionally, Judge Kuhnke's statement is incorrect. It is an incorrect application of the law. Under Michigan law, it doesn't matter whether mental illness is consistent or contemporaneous with the defendant's illegal activity. What matters is whether mental illness prompted the defendant to engage in the unlawful conduct. That is, that because of the mental illness, the defendant was unable to discern whether he or she was behaving in conformity with the law. But that's about it. Consistency or contemporaneity mean nothing under Michigan law. The Michigan statute is clear in that the defendant, here Maria Vigors, has a burden of proving that her unlawful activity was prompted by her mental illness. Maria Vigors didn't prove that. The existence of psychiatric reports talking about her do not constitute conclusive or sufficient proof that her illegal activity was prompted by her mental illness. Other defendants who have been diagnosed with the same psychosis not otherwise specified have also been convicted of their crimes. Moreover, Maria Vigors has a history of making false accusations with the police. Remember the story I covered in the third segment where Maria Vigors falsely accused my father of domestic violence. Also remember the emails where Maria Vigors was interfering with my father's employment. All those instances were long before the psychiatric crisis that Maria Vigors allegedly had in April of 2015. Even if Maria Vigors were to argue that that statute belongs only to criminal cases and that this is a civil one, Maria Vigors is still helpless under Michigan law. That is because Michigan case law makes it clear that a party who presents an affirmative defense automatically acquires the burden of proving that defense, and in this lawsuit, Maria Vigors, through her attorney, presented the affirmative defense of truth, thereby insisting in that Maria Vigors' accusations against me were entirely truthful. In fact, they were entirely false, which is why these two people were utterly unable to prove anything of the accusations from Maria Vigors. Therefore, it was completely idiotic for Maria Vigors and her attorney to even think of presenting that affirmative defense. Finley the Idiot did not even withdraw that affirmative defense when they were heavily invested in the insufficient legal argument of mental illness. Another evidence which the courts recognize as proof of actual malice in a defamation case is where the defendant denies a request to retract her defamatory statement. Well advanced in litigation of this lawsuit, I submitted my request so that Maria Vigors would retract her false and defamatory statements. Instead of making a little bit of sense, Finley the Idiot answered with a short statement denying my request for retraction. That automatically proved or produced additional proof for me in the sense that Maria Vigors made her defamatory statements with actual malice. For these reasons and other aspects which I have not addressed in this segment but will do in subsequent segments, it was extremely inappropriate for Judge Carol Kuhnke to come up with her fraudulent statements for the sake of obstructing justice. Unfortunately, the obstruction of justice by Carol Kuhnke is not limited to this lawsuit.